Hello, good evening. How are you? Can you hear me? Olanda, can you hear me? Please say hi. If you can hear me, please say hi in the comment. I can read your comment. Backlog visa, it cleared. Olanda, not yet. We'll get into it. Uh yes, Olanda. I'm happy to see you too. Uh Schmid. Yes, I'm ready. You get hello. Only two people. Come on, folks. Schmidt, you need to be sharing my videos with your friends. You can't be keeping my videos. You know what I mean? Yes, I'm happy to see you too. Yes, we got 11 people. Now we can get started. Hi, 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 hi. So, what is the subject? Today we will answer the question once and for all. Then later on, we will take your questions and we will try to answer them to the best of our ability. Hi, hi, you can hear me, right? Yes, thank you. So the question is, can I adjust status while my asylum case is pending? Okay, can I adjust status while my asylum case is pending? So this question is very complex. We're gonna answer it in two parts. First, we want to know where is your asylum case pending, with USCIS or immigration. If your asylum case is pending with immigration, can you adjust status? There's two bases, right, to adjust status: family based or employment based. So let's say you have a petition for a husband or a wife's spousal petitions. Yes, you can adjust status provided that that marriage is entered in good faith. You can even adjust status in removal proceedings in front of the immigration judge if you can prove that the marriage is in good faith. They can adjust status. But let's say that it is not based on marriage. Let's say it is based on employment. Can you adjust status? Now it becomes difficult, right? Because if you get married to a U.S. citizen, unlawful presence is being waived, right? Unless you have unless the person has other inadmissibility issues. If it's just about unlawful presence, when somebody gets married to a U.S. citizen and they can prove that the marriage is in good faith, yes, you can adjust status, whether in court or with USCIS, as long as you can prove that marriage is a bona fide marriage. But when it comes to asylum pending and you want to adjust status to employment, it becomes difficult. Why? Because unlawful presence is not waived just easily like that based on employment. Because remember, when somebody has an asylum petition pending, the person just has a permission to stay while they're trying to adjudicate their asylum case. The person is still not lawfully present. The person does not have the status. And then when that person has an employment-based petition pending with USCIS, sorry, if they have an approved employment petition, now the question becomes, at the time of adjustment of status, that person into a lawful status? But because they have an asylum case, then the person is not into a lawful status. Then there is an issue of unlawful presence. Then it becomes if they can waive it, okay? And then if the person has a qualifying relative, we're talking about child, spouse, or parent, and those relatives are either U.S. citizen, permanent resident, then they can apply for a waiver and hope that the waiver gets granted. Then they get adjust status within the United States. You see how it goes? It is really not as simple as that. At least we try to answer that. Okay. So now we can. Yeah, Alice Kambao, I have my asylum pending case. Can I do parole? If yes, how can you help me? You want to do advanced parole so you can travel? Is your asylum case pending with USCIS? If with USCIS, yes, you can apply for advanced parole so you can travel. But remember, you have to have a valid reason to go outside of the US. So if you need a consultation asylum, please email me. We can talk about it. But the answer is, if your case is pending with USCIS, yes, you can apply for advanced parole. But are they going to give that to you? That's up to them. But then remember, if you're applying, you have an asylum case pending with USCIS, you can't just travel back home or back to the country that you are fearing persecution. So it has to be clear where you're trying to go and why you're trying to go where you're trying to go. Those are the questions you have to ask yourself. Okay, so let me take some other questions. Oh, Shalom Alomba, backlog visa. My friend, backlog visa, it's not cleared. Shalom, let me share my screen with you. We can see it, right? It's not clear. I'm gonna share my screen with you so you can see about backlog, right? When it comes to backlog with the travels.state.gov, this is what they're saying. This is the report of January 2022. Okay, trying to do their best, right? And this is where they are. It says number of applicants whose case are documentarily complete at NVC and ready for interview as of December 31st, 400,065 and 9078. Okay, and the number of documentary complete applicants scheduled for interview January, 26,605. They're scheduled for interview. Eligible applicants depending the scheduling of an interview, 439 and 373. Okay, so each month they have an average of 60,000. So in other words, really patience is required. Really, at this point, due to coronavirus, it's just like there's not much really to do about it unless they hire more people and they waive more interviews. That's what they're trying to do. They're waiving a lot of interviews, especially if they look at the document and the documents are ready, so they can just waive and approve. That's what they're doing in order to actually reduce the backlog. Okay. And then, as a reminder, applicants should be as prepared as possible for their interview by bringing all required documents with them. Being fully prepared will not only speed up the interview, but also help the department more efficiently reduce the number of those waiting for an interview appointment. So I'm going to stop sharing from here, and we're going to go back to the questions. Hopefully we get more questions. Okay. Yeah, it says, ready. Hi from Florida. Hi, how are you? Chulu there. Hello. Working authorization, 6 months extension expires in September 2021. Contacted USCIS, told me to forward letter from my employer, which I did in October. Didn't hear anything. What can I do? You need to call them again. Giwa Hacking. You need to call them again to find out whether they received that work letter from your employer, and you really have to keep calling them. And we talked about the if you really try it a lot, there is this center called let me Google it and then I'll get back to you. Let me Google it and then I'll get back to you. Yeah, we're trying to find that center where you are going to try to contact them so that they can give you some type of solution if you really try. We've talked about it for my previous video. I'm trying to find out for my previous video really the name of that center. I had it in my mind, but let me try to find out how you can contact them so that you can try to resolve it. Okay. Yeah, you need to try to contact them and see if we can resolve it. Hold on a second. I'm trying to find the center where you can contact them. If I don't find it, you need to email me. Hold on. Try to find it. Yeah. So you need to email me so I can find it for you. Giwa Hakim, you need to email me. I'll find that center and I'll give you their email so you can call them and try to resolve it. Because if you've been trying to resolve this thing with USCIS and you still haven't find it, their solution, you need to contact them and have proof that you have tried to resolve it with them. Email me, Giwa Hakim, okay? My email is on display. Email me, I'll send you that information. Bharat, hi. Yogeta, hi. Can I apply for Eb2 while asylum is pending? We have answered that. You can apply for Eb2 while asylum is pending, but the problem is when you get an approved petition, I-140, the question becomes, can I adjust status? That's the question you have to ask yourself. Can I adjust status? Now the problem is you have two problems. You have a pending application with USCIS. Then you have an approved Eb2. Well, can I adjust status? Now we go back to the rule of adjustment of status. Okay, must have been inspected or parole at the time of entry, and must be lawfully present at the time you are adjusting status. But when somebody has an asylum case pending, when it comes to their status, they're not lawfully present. They just have some type of waiting period until they apply for them. So now if you're not lawfully present, you cannot adjust status. Then you start to look into how can I cure my unlawful presence. That's when the waiver came into play. And if you have a qualifying relative, you can try and see if it's going to get accepted. So Nilza de Oliveira, to answer your question, yes, you can apply, but are you going to get an adjustment of status? It's going to be challenging. That's how I'll answer that question. For Lowell, my question is, you want to file for VAWA, do we have to divorce? No, my friend, if you want to file for VAWA, you don't have to wait for a divorce. You're just gonna go ahead and file for VAWA, and provided that you have the evidence to show that you were in an abusive marriage. Okay, it can be abuse, can be financial, physical, emotional, and that's just the part 2 of the VAWA application. But part 1, you still have to prove that that marriage was valid, enter into good faith, bona fide marriage. You like to learn about the court clock. What do you mean? When you apply, when does the clock start? Alan George, you need to elaborate more on your question. Alan George, you have to elaborate more on your question so that we will know how to answer it. So anybody has a question? We had a lot of questions on Okay. My asylum got dismissed for lack of jurisdiction. However, they have sent me two letters say that they will interview, there'll be a hearing interview in 14 months. What should I do? Who sent you the letter that they've been interviewed? You should call them. And who sent you the letter of dismissal? Is it the same USCIS? They send the letter of dismissal and then they send the letter of interview. It's going to be in 14 months. Or are you talking about your case has been referred to immigration court? Then you have a hearing in 14 months. Then you have to go to immigration court. If you have a hearing in 14 months, you have to go to present yourself to immigration court. Oh, Oliveira, what do you mean by the 10 years bar? Like the unlawful, are you in the US or outside? Oh, the same USCIS? Oh my gosh. But anyway, if they sent you the letter that, did they give you a specific interview date? If they give you a specific interview date, you should show up to that interview date. And then you should call them too to find out why. Yeah, that's one note. You need to call them and find out they have two con- contradictions letters. Those letters are they're in contrast with each other. One says that dismissed for lack of jurisdiction, and one says that you have interview in 14 months, and since you have never been, they've never sent it to you. So you need to call them and find out what's going on with them. Oliveira, you are in the US and you have a 10 years bar based on unlawful presence. Do you have any qualifying relative? We're talking about parent, child, or spouse, US citizen, or permanent resident. If you do, then you can try the waiver thing. So that's the only way, to find out whether that waiver will work for you. So questions, we are taking questions today. You're welcome. Nodes, you're welcome. Yeah, Nilsa, you need to apply, try the waiver and apply for it and see where it's going to lead you. So does anybody else has a questions? Amen. You're thank you, Ami and E. Thank you very much. We're trying to do the best that we can with what we have, right? So if you have a question, please leave it in the comments. Yeah, this thing dash deep post guy dash. I know there's a real backlog with asylum pending with USCIS since 2014. The question is, if you have a work permit, it's a good thing, at least you can work. But if you have family outside of the country, you can try expedited request and see where it's going to lead you. But remember, with expedited request, you have to have a strong, really reason so that they can expedite your case. Or another option is if you have a family outside the US, you can try to apply for advanced parole and see if they are going to approve you for that. So those are the three options you have. Try expedited request, try advanced parole, and see where it's going to lead if your case is pending with USCIS. How long it takes to reply after responding to notice of intent to deny? Well, usually take them 60 days. But nowadays, Lucas, my friend, nowadays, USCIS does not care about anything. Their own timing, they're really behind. So under normal circumstances, 60 days is enough for them to give you some type of decision. If 60 days has passed, just wait. Maybe within 6 months, you hear something from them. But after 6 months, that's when you should be calling them. Alice Kambu, you live in Vegas? Do you have a hearing? Or are you trying to just to apply with USCIS? If you're applying with USCIS, yes, contact me by email. We'll work something out. But if you are in removal and you need representation in court, then there's a lot. Gorfi Alphonse, you email me, please. I need your help. Okay, I'm gonna read the email and see what you're emailing me about. If it's a long question, then you really have to pay for consultation. But if it's just about finding out something quick, I can answer you. Anita De Souza, what are the options for someone who has a removal case pending in May? And don't what? Anita De Souza, your question is not complete. You need to complete your question. What are the options for someone who has a removal case? So you are in removal. You mean what type of defense you need? You need to really ask your question completely, De Souza, so we can try to answer that. Okay. Yeah, Denita De Souza, if you remove a proceedings, one of the defense is asylum. If asylum doesn't work, then people move to withholding of removal. If you have a way to adjust status to spouse or employment, you can bring that too. Or if you have a way to adjust status to your child, 21 years old or older, you can bring that as a defense. Or if you qualify for cancellation of removal, that could be a defense. So it just depends on your situation and the facts of your case. So that's how we will answer that one. Okay. So any question? Oh, you don't this is you don't have a lawyer. You need to find one. You really need to find a lawyer, otherwise they're gonna make you sign the things that you don't understand. Try to find one and try to work with them. You need to find somebody in your state so that you don't have to pay for transportation. Ibrahim Fatai, you want to file for VAWA? No, you don't need to divorce before you file for VAWA. You can just file for VAWA right now. If you qualify for VAWA, you can file it as soon as tonight or tomorrow. With VAWA, there's two parts to it, right? The first, you prove whether the marriage is valid, enter in good faith. Then the second part, you have to prove abuse. Abuse can be financial, physical, and emotional. So if you can prove it, then yes. Amy and me, just look at the screen. My email is right there on display. Just look at the screen. I don't think you're looking at that screen. My email is right there. You need to ask your question here. So if you keep emailing me and it's a difficult question, I'm gonna ask you for consultation fees. If you have a question, direct question, just ask it right here. We can answer it. Today we're taking free questions. You see? So, any more questions? If we don't have more questions, we're just gonna hang up. Just trying to see if we have more questions. If we don't have more questions, we're just gonna hang up. Okay, Alfonso, let me answer your question right here. Alfonso, oh, email is not clear. Oh, Anita D'Souza, you have to find a lawyer, okay? Because you can't just show up on your own in removal in May. You have to find a lawyer and talk about your case so that they can help you with some type of defense. This is what you have to do. Hippolyte Gassano, change of status. Do you have any uh, spouse, US citizen, employment, trying to petition for you? That's how you can change the status. Either family based or employment based. Only two ways. I want to file for asylum, but I've been to the US for 12 years already. Wow, that would be challenging, very challenging. Anita, that would be very challenging because you've been in the US for 12 years. Um, but when did your visa uh, expire? Your student visa expire? I believe that you went to school before the expiration of your visa. So you need to, Anita, you really need to find a lawyer to try to help you out with removal. Do you have children born here? Is it possible someone apply for VAWA for misconduct of a lawyer? No, VAWA is for abuse. Either the person who abused you is your spouse or your child or your parent, and that person has to be either US citizen or a lawful permanent resident. Misconduct of a lawyer is not a ground for applying for VAWA. You can file a complaint against the lawyer based on whatever they did to you, Gorfi, Alfonso. I don't know what they did to you, but you can apply for VAWA based on the misconduct of a lawyer. So that's the question. Yeah, Gorfi Alfonso, you email me based on your you want to apply for EB3 religious worker. I'm gonna ask you a couple questions here. If you're live, you can listen to it. I email it to you too. First of all, are you working for them? What position? How long? And then second question is, do you have, if you are unlawfully present here, do you have any qualifying relative? Spouse, child, US citizen, or lawful permanent resident? Because the problem will be you can apply for EB3 and get approved, but if you are unlawfully present and you don't have a qualifying relative, it's going to be difficult for you to adjust status. So those are the three questions that I'll email you. If you answer it, then we can evaluate your case. I charge for consultations, okay? So yes, Ibrahim, you can go with VAWA while you're still married. As a matter of fact, you should apply for VAWA like tomorrow. If you have the proof that you're talking about abuse, if you have it, then you should apply for VAWA tomorrow. And if you want me to be your lawyer, then you can email me, then I'll let you know how much I charge. No, qualifying relative can only be a spouse, a child, and a parent. And they should either have a lawful permanent residency or they should be US citizen. While the case is pending, you cannot. The case has to be approved first. Then you can bring your family. And we're talking about your spouse and your children, that type of family. qualifying relatives, not just your sisters and brothers, not like that. Sarhi too cool. We go back to the same problem, right? Register nurse. Can you adjust status? The answer is simple. You can adjust status, but the problem is, how are you going to cure unlawful presence? Because once a person overstays a visa for 10 years, they become unlawfully present in the US soil. So how do you cure unlawful presence? You can cure it with a waiver, but how does the waiver works? You have to have a qualifying relative to apply for a waiver. Has to be parent, child, or spouse. Must have either residency or they should be US citizen. But that's how it works. Yeah, Godfrey Alfonso, your case got dismissed for lack of jurisdiction. And then they send you a letter saying that you have an interview in 14 days. So the question is, the same people send the letter of rejection, of dismissal, as the same people who send the letter of interview, and you haven't gotten an interview. That one, you should call them, try to find out what's going on. You're welcome, cool. No, a cousin does not. No, you're kind of like blocking your ear, right? You don't want to hear it. No, no cousin. Gotta be wife, spouse, gotta be spouse, parent, or child. Must have citizenship or residency. That's it. So as simple as that. Nooks, you don't want to hear what you just want to hear what you want to hear. Maxoluma. Hi, how are you? Thanks for joining us. Do you have a question? We're taking free questions today. We are totally taking free questions today. We're totally taking free questions today, and it's gonna be better if you actually ask your question so we can answer it to the best of our ability. That's what we're doing today. Taking questions. Gofi Alfonso, you say you have minors, relatives born here, kids born here. So you already have something to work with. Now the question is, if you're working at the church, what is your position there, and how long have you been working there, and are they willing to sign the petition for you? So those are the questions you have to ask yourself. If we can figure that, then we can evaluate your case and know where you stand. Yeah, no, not in 14. They said they've been. Yeah, he needs no. Whatever was waiting for 14 months, they have to call USCIS and find out what's going on. What do you mean, Luma? What do you mean by work permit visa? Yeah, Gorfi Alfonso, you need to call them and find out what's going on. First, they dismiss the case, then they send you a different letter. It's like there's two contradictions there. I mean, you're not getting it. The person who needs qualifying relative, if that person is unlawfully present, if the person has overstayed the visa, that's when they need a qualifying relative, so that when it's time to adjusting status, they can have some ground. That's what I'm saying. If you are lawfully present, you don't need a qualifying relative. Amy, did you get it? Oh, since 2019, my friend, some people have been waiting since 2014. So this backlog is taking forever. So I don't know what to tell you. If you can expedite it, try the expedited request and see where it's going to lead you. But you have to have a good reason to try to expedite your case. EB2, you can file for yourself without an employer. Basically, EB2, you can file it for yourself. That's the purpose of EB2. But my question is, what is your current status now? Because you can file for EB2. It's just a form, right? I-140, you meet the qualification, you file. And the form might get approved. But the problem is, how are you going to get a green card if your current status is outside? It's like you overstayed the visa. How are you going to get the green card? That's where the qualifying relative come into play. Amy and Nee, did you get it now? Yes, you can file for EB2, and EB2 does not require an employer. You can file on your own. And when it comes to adjusting status, you must be lawfully present with no criminal records. Thank you, Amy. Amy finally get it. The way this game works. This is the immigration game, not my fault, my friend. This is how this immigration thing goes. Frank Olivier. If your child is a minor, can you help? What do you mean, first of all? If the child is minor, we use the child for a waiver. If the child is over 21, US citizen, then the child petitions for you. So I don't know which way you want to go with that question. You gotta ask it, you gotta rephrase that question. Frank Oliver. So, oh, you legally present? Yeah, Amy, if you're legally present, then you should apply for EB2. Oh, Luma, you like to know about work permit. But if you apply for asylum 2 years ago, Luma, you should have your work permit already by now, because it takes only 1 year to get your work, to be ready to get your work permit. And if you apply for asylum 2 years ago, you don't have a work permit, then there's a problem. So you need to consult, pay somebody to find out what's going on, because you have to have your work permit if you already applied for the asylum 2 years ago. But if the asylum hasn't been getting the interview, the problem is backlog because everybody's waiting. Yes, you can get, Frank, you can get a consultation with me in French. I charge 175, okay? Amy N.E., email me your detail. I'll let you know if you can apply or not. Yes, I can get, Frank, I can get a consultation French, but you have to pay 175 for the consultation, okay? I do 1 hour consultation. Whew, I guess we got all the questions answered. So this is it for tonight, folks. We're here for Amy. Okay, what is your second question, Amy? What is your second question? Amy, you need to share my videos with your friends because I'm answering all your questions today for free. You need to share my videos with your friends, Amy. You better share my videos with your friends so they can subscribe, and your family members. So, Amy, we're waiting for your second question. What is your second question so we can wrap up? Oh, Kapera Lulasha on Facebook. On my Facebook page is asking how long it's taking to apply for N106 for children to get the citizen certificate. Okay, let's answer that question, Kapera. We're going to share the screen, okay? We're going to share the screen and answer that question for you. Share the screen. Share the screen. Then we go to processing time. USCIS, processing time. Okay, when we go here, we file N600. Where is it? N600. This is N600. Depending on what service center you're filing or where you live. Let's say you live in, I live in Washington, D.C., right? Or let's say, let's just give an example. Let's say you live in Jacksonville, Florida. Okay. This is the processing time for Jacksonville, Florida, between 8 to 16.5 months. That's the processing time. So you need to go to that website, put the form number and the location, then you will know for sure what processing time. Stop sharing, go back. Kapera Lu Lasha, I hope we answer your question for you tonight. Your friend has an asylum pending. Can they apply for Eb2? The answer, we already answered that, Amy. The answer is she can apply. But the problem is, can she adjust status? When it comes to pending asylum and adjusting status, there's two things that's going on. First of all, there's the person with pending asylum case with USCIS, they're not lawfully present because asylum pending is not a status. So now the second question becomes, does your friend has any qualifying relative? Because when it comes to adjusting status, because she has a pending case of asylum, she's not lawfully present, the problem of unlawful presence is going to come into play. So that's why we ask you, if she has a qualifying relative, then she can have a waiver and hope that the waiver get granted. Amy, I think I've answered this to the best way possible. Anita D'Souza, you ask for his statement get denied. Yeah, you can try again and see how it's going to go. But for your removal proceedings, Anita, you need to have a lawyer present. Amy, thank you for sharing my video. Please share it. Oh, Capera, thank you. I hope you satisfy. You're welcome. Yes, Amy, EB2 is national interest waiver. That's why it's called national interest waiver. You apply on your own because you want to you want to tell this government that you are so capable. That's why they should give you the green card on your own without an employer. So that's the problem. And you have to tell them that it is in the best interest of them to give you that green card. That's why it's called EB2. You don't need the employer for that. You just need to meet the qualification for EB2. And once that person applies, now the question becomes, once they get approved, will that person adjust status? That's when we look at those. Were you inspected at the time you entered the US? Are you lawfully present? Do you have any criminal record? Those are questions that comes later on in the process. Because anybody can fill that application EB2, but the problem is, will they be able to get the green card? Amy, that's where the problem is. So, Kapera Lulasha, where to send N form? Let's go back and answer again that question for you. Where to send it? Today we're answering all your questions. You better be sharing my videos, okay? So, Kapera, you just go on Google and you do direct filing of N600. Okay. You can file it online, but if you're filing in paper form, you have to hold on. The direct filing of N600. Yeah. It's supposed to give you where to file it. Okay. Anyway, we go to the website. Usually it gives you where to file it here. You can file it online or you can send a paper form. You see where to file, okay? You just go to uscis.gov, you click on 600, you scroll down where to file, it gives you where to file, okay? This is where you file that form, okay? So pretty much this is where you file it if you're filing paper form. So I hope you see it. Very simple. Yeah, so you saw it. You're welcome. Your hearing is in California, but you're currently in Colorado. What do you mean your hearing is in California and you're currently in Colorado? So why your hearing will be in California when you reside in Colorado? You need to change venue. When you get your lawyer, ask your lawyer to change venue for you. Huta Huti, answer please. What type of question did you ask? Nathaniel Nigos. What about what? Kopera Lulasha. Please go ahead and share my videos with your friends. We've answered all your questions. You're welcome. So, Natalia Huta, I don't see your questions, so there's nothing to answer to. So I don't see your questions. There's nothing to answer to, and I hope you enjoyed this live stream. Oh, thank you, Kopera. Thank you very much. Much appreciate. Much appreciate. Yeah, thank you very much. Okay, so I guess this is it, right? Oh, there's one more question. We have an asylum pending and also the I-1 approved since 2000. Can we apply for Eb2? Katimbenge, we have talked about this Eb2 from the beginning. The answer is yes, you can apply for Eb2. But the problem is, because you have an asylum pending, it means that you're not in lawful status. When it comes to later on adjusting status, the problem of unlawful presence is going to come into play. Asylum pending is not a status. So you have to find a way to cure that lawful presence. That's where people with children born here have better chance, because they can use those children to get a waiver, to waive that unlawful presence for them. So that's how we're going to answer. But Kathy, because you come at the end, you have to rewatch this video, because it has been all about Eb2 today, really, with asylum pending. So please rewatch that video. You get a better sense of all those answers. Your sister is a U.S. citizen. Of course, they can petition for you, but remember, it's F4 category. It can take up to 15 years for that petition to be approved. And then by the time the petition is approved, are you going to be lawfully present to adjust status? That's the second question. Oh, Anita, if you move to Colorado, you need to change venue. You need to transfer venue. So the lawyer that you're going to get, they're going to help you transfer venue to Colorado. How long did you, Kopera Lulasha, how long did you stay in Africa when you traveled? 2 times, but for how long? If it's less than 6 months, you should be fine. What is Eb2? Eb2, really, this is gonna take forever. You just need to Google it. Eb2 is when somebody's petition for a green card on their own, trying to convince the government to give them the green card. Henry Limage, I have a video about Eb2 on my YouTube channel. Just check on it. It has all the detail. I have called for biometric before 6 months. My question is, am I waiting for interview? Oh, when it comes to interview waivers, it's just up to them. really, I can't tell you whether they're gonna wait the interview or you're gonna go to the interview. They just look at the document and they decide. Right now, they're waiving a lot of people interview. Huta huti. They're waiting. They're waiving a lot of people interview. So you might get a chance. They can waive it, but I cannot confirm it. It's just you just have to wait and see. 5 months. 5 months is less than 6 months. I think it should be fine. If you have asylum pending with USCIS, well, you can get a lawyer before the interview so they can prepare you for the interview. It really does help. So in total, Capera, let's get this straight. In total, you have been outside of the country for 8 months within 5 years, or then we have a problem. I don't know if you've done your 5 years thing. So maybe it might not really, to be honest, but you're gonna have to double check on the USCIS website. Huta huti, you're welcome. You're welcome. You're in Kentucky. Okay, once you're ready for the interview, you can call me or email me so we can prepare you for the interview. Then you can pay me. So that's what we're here for, right? To help you get what you get and to help me get what I need. So how to process it? Please answer me, Nathaniel Negros. How to process what? Oh, you never have a case. Well, now you have two problems, right? Gonza Kelly, you have two problems. You have two problems. You have a lawful presence. If you get married, spousal petition to a U.S. citizen, that's gonna help you. Anita, if you're in removal, first you have to show up to court, right? And in court, that's where you put all your defenses. You can apply now, hopefully they get it for you, then you can show it to the judge, but you still have to show up in court. Who took your lawyer? Who took your money? She's not a lawyer. Emmy, ask Emmy, you need to email me for those type of questions, okay? Please email me. Natalia Negros. Natalia Negros. Oh, Natalia Negros, you file for Natalia Negros. If you have a sister petition for you, they use the form I-130. Then your sister file for you, but just know that siblings petition can take up to 15 years. But the process is the petition, the person who's your sister will file the form I-130. I've talked a lot today. 1 hour. I think this is it for today. This is it for today. Okay, we got enough. You guys need to be sharing this video with me. Emmy and me, please email me with that question about how much I charge for Eb2. I'll give you all the possible action. Okay, Coopera, please email me. I'll give you the answer. Ganza Kili, you have to go to court. You need a lawyer. If you have to go to court, you need a lawyer. Why would you go to court? Did you get a notice to appear in court, or are you just going to show up yourself? Nathaniel Negros, are you in the US or outside of the US? Oh, Gonza Kelly, you're not in removal proceedings. You just want to know if you can adjust status. Well, there's two ways to adjust status, either family or employment, okay? If it's family petition, what's going to happen is it has to be a spouse for it to go smoothly. If it's not a spouse, then you have a problem because you've been here without a status for 12 years, unlawful presence. You might request a waiver if you have qualifying relatives. So that's the only way I can answer that. Yeah, Natalia Negros, you're here in the US, your sister will petition for you, but still it's gonna take 15 years before you, up to 15 years before you get the approval. And once you get the approval, you're gonna be faced with that unlawful presence type of problem. Hopefully you're gonna get that answer by the time. Maybe you have children, so you can use a waiver for it. I talk a lot today. Amy, you need to email me so I can give you the specific answer about the pricing. And you need to be sharing my videos as well. Gonzakili, please share my videos as well. Thank you very much. I really appreciate you coming here. It's already almost 6:30. So we did 1 hour. That's good. We really did well. I hope the best for you, for your immigration process. Hopefully it gets smoothly, and hope this administration is going to come up with something this year, really, at least. But anyway, until next time, bye-bye. Ciao. Thank you. Thank you very much.